SJC-12759, Robert Smith v. Robert Kelley.
Mr. Baker, good afternoon.
Good afternoon. May it please the court, my name is Jeffrey Baker. Together with Jonathan Plout, we represent the appellant Robert Smith. We are appealing from the summary judgment ruling of the Norfolk County Superior Court. We argue that the court incorrectly found that the successor liability doctrine did not apply to the defendant, Robert Kelley. We are also arguing that the trial court incorrectly found that there was sufficient evidence in the record to justify veil piercing and holding accountable Mr. Kelley individually. We believe that's a triable issue. And lastly, we argue that the trial court incorrectly conflated the remedies of successor liability and veil piercing with fraudulent conveyance remedy to determine that the limitation of damages was the value of the corporation, the PC that was dissolved at the time of its dissolution.
You skipped issue and claim preclusion.
With respect to claim preclusion, we do not believe that our claims are precluded for two reasons. The matter of veil piercing was not limited to presenting it in the federal district court action, Your Honor. Specifically, the basis for the veil piercing is the fraudulent activity that Mr. Kelley engaged in after the judgment entered. And on that basis, Your Honor, I do not believe that we would be barred from presenting it. The court cited the Evans case as the basis for suggesting that the federal district court was the proper place for bringing the veil piercing claim. I submit that the Evans case holds that Mass R. Civ Pro 69, which is on the state side, applies to allow a judgment creditor to engage in post-judgment discovery.
So I understand that, and I also understand, it's a good point, you make the point that what really is the gravamen of what's going on here is what happened after dissolution anyway, which hadn't occurred in federal court. So I understand that position, but nonetheless, what about what the trustee estate had? And the trustee estate, I know that what the trustee estate had and what the PC purchased said, no successor liability included, no piercing the corporate veil included, but nonetheless, the trustee had claims that the PC could have brought against the shareholder, which might have included piercing the corporate veil.
So in addressing that, Your Honor, all that happened on the bankruptcy side of this case was that the trustee sold the claims that the trustee believed the estate had to Mr. Kelley personally. And there was no res judicata effect of that transaction. It's 11 United States Code section 363 that the trustee was making the motion under, which allows for a private sale.
PC was the creditor.
Well, our position on that is no, that Mr. Smith had a private right, and that's exactly what the Norfolk County Superior Court also found, that these claims were not claims of the estate. And the Superior Court made that ruling, which we believe is correct.
I just misstated. I used the wrong word. I used the wrong word.
Oh.
The PC was the one that declared bankruptcy.
That is correct, Your Honor.
So now the trustee has what the PC might have had, and therefore there could have been an attempt to pierce the corporate veil by the PC against the individual.
So two observations. One, those claims were specifically reserved and not resolved in the bankruptcy court. Well, three observations. One, that. Two, the trial court on the state side and the Superior Court made a specific ruling, and I think I quote the language, plaintiff has the better argument on this issue, which is those particular claims are not claims of general harm to the estate of the creditor, to the estate of the debtor, I beg your pardon, which is Mr. Kelley's PC, but rather they are unique and specific to Robert Kelley, and it is for that reason that those claims survive.
It's odd, isn't that? That's an odd ruling, isn't it? Because the bankruptcy court is sort of saying, I accept that this is not sort of fraudulent, right? Because they're allowing the bankruptcy proceeding to go ahead, right? They're closing out this bankruptcy proceeding and leaving this claim out there, right? It's an odd, and saying, well, I'm not putting a great value on it, but I'm allowing you to keep it.
Your Honor, all that happened in the bankruptcy court was that the trustee sold the claims. There was no ruling on the merits of any of
But
this.
they didn't dissolve they didn't say this whole thing is shenanigans and we're not going to buy into it, right?
That's correct. There was no
they-
finding to that effect.
They basically allow this to go forward, particularly, and also we're talking about, besides attorney's fees, we're talking about $25,000, right?
Well, it was trebled because there was a 93A finding
The
of,
$25,000 owed to Mr. Smith was troubled, or the attorney's fees under 93A are troubled?
no, the award of damages in the federal district court against Louis Bertucci was
Right.
in the amount of $25,000. Judge Stearns then trebled it to $75,000 and then added, I think, about $160,000 of legal fees. After we took our trip upstairs to the First Circuit and then came back,
Right, but so the bankruptcy court sort of allows this to go ahead, minimizes the claim, but separates it. And then, I'm just trying to understand where this is going. And then we have, because your whole basis for your claim is that what he's doing is improper, right? That, he's misusing the corporate form to wipe out this liability. And you may very well be correct, but the bankruptcy court doesn't feel it's improper in the sense that it's allowing this all to go forward and actually describing it as not a very viable claim. I'm not sure it's right, but we don't get to review the bankruptcy court.
respectfully, Your Honor, I disagree, and I'll say why. I don't think that the bankruptcy court said that. I think that's what the trustee said in the trustee's motion. The trustee said, we value these claims to be of dubious value because we do not know of any case precedent involving the dissolution of a corporation and the transfer to a sole proprietorship and successor liability.
Right, but when you want us to focus on this successor liability, particularly the fraudulent aspect of it.
Correct.
But the bankruptcy court didn't sort of treat this, if it were really troubled by fraud, wouldn't it have not allowed this to go forward?
No, not at all, Your Honor, and I'll tell you why.
Okay.
My view, I was at the bankruptcy hearing.
Right, no,
My view is as follows. I don't think the bankruptcy court cared. If the trustee says, we want to sell these claims, the bankruptcy court is going to have a hearing, and the only real issue, aside from maybe title issues, which are not present in this particular matter, is what's the value? Does anybody object to the value? Is there going to be a higher bid? And the claims were sold from the estate of Robert Kelley PC to Robert Kelley individually. The court made no ruling and really took no position.
So you want to be in the same position, well, I'm not sure of the answer. Do you wish to be put in the same position as if the Kelley PC was disbanded and he then operated his law practice as Kelley 2 PC?
Yes, Your Honor. You're drawing the distinction, as I understand it, between the successor entity being a corporation versus a sole proprietorship.
Right.
We see no distinction. We see no-
So let's imagine that he had done that. Let's imagine that as opposed to being Kelley sole proprietorship, he had created Kelley 2.0 LLC. What would you have gotten from Kelley 2.0 LLC if the successor liability had kicked in?
It is our view that so long as, to use your example, Your Honor, the successor, Kelley PC2, was in business and operating and earning funds, we would ask that this court or the trial court to hold that successor corporation liable for the full extent of the debt until such time as it is retired. And that's what we're asking this court to do against Mr. Kelley individually.
But you'd still have the limited liability of that new corporation.
That's correct.
And do you have more now that he formed a sole proprietorship? Should we limit the scope of what you get to what you would have gotten had he formed a second PC?
The correct analysis, in our view, is not what is the liquidation value or what is the sale of assets value, but really and truly, Your Honor, what is the value of that successor entity on an ongoing basis? Let us assume, to use your example if I could, let us assume that that successor corporation, Kelley PC2, continued to engage in the practice of law, just like what we've learned, for at least 2 more years, because we subpoenaed in our discovery Mr. Kelley's tax returns, and we deposed him. And in the record, it is clear that he made $160,000 in 2016 and $200,000 in 2017, and he was going to continue practicing law open-endedly. And in that instance, the value of the assets is minimal, but the value of that corporation to continue to earn is much greater. And we submit to this court that we are entitled to get paid out of that. And that's what I think the cases hold. And that's where I think the Superior Court went wrong. The Superior Court applied the wrong standard of damage. In one of its rulings, in one of the statements in the opinion, the court said, we are not going to give Mr. Kelley more than what he would have gotten based on the value of the corporation when it was dissolved. I submit that that's an incorrect standard. Rather, Mr. Kelley is entitled to receive all that he would have received if Mr. Kelley were to continue practicing law, because if Mr. Kelley had not engaged in the fraudulent, wrongful conduct
But he hadn't. That's the thing. It was vicarious liability. Nobody said that he did it.
I'm not talking about the issues that were tried to the district court. I'm talking only, Your Honor, about the liquidation of the PC. If Mr. Kelley had continued to practice law in the PC, we would have been able to seize, attach, get paid out on some basis through our post-judgment Rule 69 discovery and remedies the monies that he was earning. And his testimony and tax returns show he made about $400,000 just over the 2-year period that had passed up until the time that I took his deposition.
But
and
that
that's
would-
why I submit that this is not a punitive
That wouldn't work.
action.
That wouldn't work. If this were a 10-person PC, for example, this were a 10-person
I heard you,
PC,
Your Honor.
and it broke up, and then one lawyer went off on his own and started making money, you'd have no right to that person's money, right?
I think that's a fair statement, Your Honor.
And particularly under the ethics rules, if that one person wasn't responsible for the negligent conduct, again, expressly exonerated for that. So it really is tied to the fact that it's basically him before and him afterwards, right? It's not, this corporation stuff is attractive, but it's that he was the corporation before and he's the entity afterwards. It's the individual facts here, because it doesn't work. We're not really dealing with corporations, you know.
I completely agree, Your Honor. And if you apply the Guzman-Cargill factors that identify successor liability, there are 4 independent bases. Any one of the 4 will do. There are 4 independent.
The problem is that he has to have a right to continue to practice, right?
No dispute.
That's where it gets confusing, because he's a solo practitioner, and I mean, he doesn't declare bankruptcy himself the first time around. That's where this thing gets all messy.
Judge, he has the right to practice law. He doesn't have the right to practice fraud. Shutting his business down and starting up.
But again, what bothers me is the bankruptcy court allowed this. You know, it didn't And you didn't object, right, to this as being improper in bankruptcy
We
court?
didn't object to the value of the sale of the claims. That's all that happened, Your Honor, in the
You
bank.
also didn't object that it was a misuse of the bankruptcy process, did you?
No.
Ms. Bader, I want to.
Yes, Your Honor.
I want to send you in a different direction, because, you know, the successor liability is an important, interesting argument. We've never really evidently applied it from corporate to solo practitioner to a sole proprietorship. But there was an amazing amicus brief in this case, a really well-done amicus brief in this
I
case.
agree with Your Honor.
And that well-done amicus brief that it's not supposed to, and it didn't take a position, but it talks about SJC Rule 306.
Correct.
And while this case does not fit in perfectly, it actually doesn't fit into 306.
That's right.
Because of the many reasons, not a malpractice issue.
Most notably, he's not a client.
Not a creditor, all that stuff.
Right.
But nonetheless, it points out that we have to take responsibility and recognize our responsibility as it relates to the practice of law in the bar. And maybe this is a situation where, looking at 306, there should be successor liability when you're dealing with PC that ends up being a sole proprietorship.
I agree with that
But
statement.
that's the amicus position. And why doesn't that, if we adopted that, wouldn't that be sufficient?
Oh, if you're saying that successor liability should attach, that's what we are looking.
It would be a derivative of 306 in these circumstances. Would
know,
that work?
What I found, the answer is yes, so long as the case makes clear that that's what happens. And if
But I
could
thought the amicus says 306, and I read, it's a good brief, but 306 isn't the answer. We would have to do it through our superintendent's powers,
It's
or,
not covered into 306.
Well,
Absolutely.
what 306 does say is that all remedies, statutory and common law of corporations, still apply. And under the circumstances of this case, I don't know how Rule 306 would bar this court from making the determination that the successor liability doctrine would apply.
Justice Kafka's right. It wouldn't be 306. It would be superintendents derived from 306.
So let me try to answer the question in a different way, if I could, please. I recognize the right, and I commend the amicus curiae authors. It was a very well-written brief, and they made interesting points that I didn't think about, and neither did the appellee. They make the point that there should be a free opportunity for lawyers to practice and for a client to choose a lawyer. And I am not trying to limit that unfairly or unduly. The amicus curiae brief did make one point, which was it would be the impingement of the practice of law is wrong. My suggestion is that's true, but it would not be wrong to unduly impinge the practice. Excuse me, I got it backwards. Sorry, Judge. It would be fair to limit the practice of law where the circumstances justify. And in this particular case, the circumstances are clear. The successor liability doctrine is met on virtually every factor and every element. And simply because Mr. Kelley is a lawyer does not mean he should escape liability of paying that judgment.
Okay, thank you.
Thank you very much, Your Honor.
Mr. Kern.
Good afternoon. May it please the court. Dana Curhan for Robert Kelley, and with me is James McLaughlin. I think I want to start out by saying that we reject the narrative that there's fraud involved in here. This was a case where everything that Mr. Kelley did was above board. Yes, he did dissolve the corporation, professional corporation, and he began practicing on his own. And yes, he did go through bankruptcy. He did it all legitimately and above board.
I understand all the, and it was helpful to get the background about attempts to settle and everything that you put into the brief. And I appreciated that perspective. But, you know, it's the first day, the day after, maybe it wasn't the verdict, but the day after the judgment, and then he talks about how basically, yes, figuratively at least, he just put up a new shingle. And neither of those were particularly helpful for that argument you're making.
Well, I mean, I think it was a long process. At the beginning, when the fraud was, by the associate was first discovered, Kelley PC was, had 12 to 15 people working for it. There was a gradual process of winding down the PC, changing the focus of the practice. I think there was a hope that the judgment was going to be small and that it could be paid off, and that would be the end of the case and it could continue. But once it became clear that the PC was no longer viable, yes, he did dissolve it, and yes, he did put the PC into
But the P-
bankruptcy about
why
a year and
was
a
the-
half later.
Why was the PC no longer viable? The PC was making money, it had clients. Mr. Kelley doesn't declare bankruptcy, it's the PC is put into it, but it's not really a bankrupt classic. I mean, I understand the bankruptcy court sort of process it, so I guess that maybe that's the answer, but.
Well, the PC had a judgment against it of $250,000, more than that. So it was, and the only income, the minimal assets, the only income were,
But had
was
clients.
the clients and actually the work of Mr. Kelley. He was going to continue to work, and they were not making, the clients were not there because it was the PC. Clients were there because of Robert Kelley.
Well, because the PC was Robert Kelley at that point. That's the thing that gets really tricky, because the PC, you're focusing on the earlier time period when Mr. Bertucci is defrauding Mr. Smith. But by the time it closes, the PC is Mr. Kelley and his wife, right?
I would agree with that, but I would say that there was a long process where it got to that point, and at that point where he has now changed the focus of his practice to, we're not doing the real estate conveyancing and all the other things we're
But
doing.
don't we look at, when we do don't we look at the end rather than the evolution? I'm confused by that, because when the bankruptcy court is looking at what the entity is that's going into bankruptcy, right? At that time, it's just him and his wife, the computers, the small amount of assets there. And then he ultimately just does just what Justice Loy was saying. He metaphorically changed the name, and it was the exact same thing the next day.
It continued to evolve. I'd say if it was PC1 versus PC2, and it continued in the same form, I would agree with you. I think
But don't we look at when it goes into bankruptcy, isn't that the PC we look at versus what comes out of bankruptcy, as opposed to what the PC was? We don't look at General Electric, in its days of glory, or I'm using the wrong case, but we don't look at a big company that was once powerful, but we look at the company that went into bankruptcy and what comes out of bankruptcy, don't we?
I think we do, but I think we also have to look at the sort of evolving process where, yes, he stayed in the office space until the lease was up, and then he moved. Then he changed the phone number because he was somewhere else. And he changed the nature of the practice. So I think when we're looking at whether the two pre-bankruptcy and post-bankruptcy, or pre-dissolution and post-dissolution, we can look at that as a snapshot. And if you look at that as a snapshot, you're going to see a substantial similarity.
I just want to know what the law tells us to do, not, you're posing an intellectual question. What does the law say we look at?
Not clear, because we've talked about PC1 versus PC2, or Corporation 1 versus Corporation 2. We're now looking at, okay, this PC has been shut down. There's no need for a PC. They're probably, once the judgment issued.
Well, there's no need for Mr. Kelley to have a PC, but there's certainly a need for Mr. Smith to have a PC.
That's probably accurate, but as far as Mr. Kelley, once expecting a relatively small judgment, and then he gets a relatively large judgment, he can look at this and say, okay, there's no reason for me to have a PC to practice law, and there's no reason, and this PC, by the way, is now insolvent because there's a judgment that it cannot pay. Now, one way we could look at it is we could do all of the pierce the corporate veil and successor liability, but I think that's problematic because it says, okay, Mr. Kelley, you either have to jettison all of your clients and tell them go somewhere else and not represent them and just walk away from everything.
Right.
And he gets nothing, or you can continue to practice law and the next 160.
There's another option,
But-
which is that he pays the judgment
Right.
and he works out. I mean, from what I understand, you tried to settle this case, but I understand he gets to keep practicing law. You can't prevent him from doing that. Does he have an ethical or other obligation to pay this judgment against himself? Because he doesn't declare personal bankruptcy. He just puts that PC into bankruptcy.
No, he doesn't
And it
declare.
may be a brilliant legal maneuver, and it may be proper, I just don't know, but I'm wondering if it's ethical from a lawyer's point of view, because there's something that leaves you with a bad taste in your mouth here.
Well, I mean, I think we have decisions from 9 years of federal litigation saying that he is not personally liable. And so,
PC
You know,
is-
you know,
Vicarious liability.
I was going to say that, it seems to me that the problem here is, as the amicus brief points out, you may have unique facts here. You may have a sympathetic person here. But what do we do with the fact that if we say this is okay, we've just made a roadmap for every other lawyer who's in a similar situation, gets a judgment against his PC, and says, oh, well, okay, I'm going to dissolve it. I'm going to go into practice for myself. How can that be okay?
well, I mean, when you look at what the legislature says that limits on liability should be the same for a PC as it is for a 156D corporation. Now, if we say,
As for an ordinary corporation, you're saying limits of liability should be the same?
well, that's what 158,
No, I just was trying to find
A6.
out what was you comparing it to? You were comparing it to an ordinary corporation.
156A, Section 6 says that the personal liability of a shareholder of a professional corporation organized under this chapter shall be no greater than, in any respect, than that of a shareholder of a corporation organized under Chapter 156D. If we now say that that's not true, that somebody who has an insolvent PC cannot avail himself of bankruptcy protection, then that changes what's in the statute.
So, there's only one reason, it seems, that we go from a PC to a sole proprietorship, and that's the judgment. And is that okay for attorneys with our profession to be able to do that? I mean, that's what sort of Justice Link is sort of getting at, I think, with that last question. Whether it fits precisely into piercing the corporate veil, it doesn't seem to. Successor liability, maybe 2 out of 4 of the factors are there, but it just feels uncomfortable for us as a profession to be able to allow a lawyer to say, okay, well, I have this liability as a PC, but don't worry, I'll metaphorically just change the shingle and go back to work the next day, the same as I was the day before. Maybe not the same as I was at the time of the judgment, but the same as I was the day before.
Well, I'm not sure if that issue has ever been raised in this case, and I don't think it was before the trial judge, but I guess, a broad answer to that question might be if Mr. Kelley, in his spare time, owned a muffler shop, why couldn't he run that through bankruptcy if it's insolvent?
We all need to have our mufflers working, but there are certain obligations that go with being a lawyer. And I just don't think the analogy works.
Well, I mean, if we look at what the federal courts did, the federal court said he had no knowledge of it and was not involved in the fraud and found him to be not responsible for it. That is the U.S. District Court twice and the First Circuit.
How do we limit it, though? How do we limit it to those facts? How do we do that so it's not a roadmap for fraud roadmap for lawyers in the future? As the amicus brief warns.
I'm not sure if this is, I mean, I think
Why wouldn't
that,
any lawyer in the future do this?
I'm sorry?
Why wouldn't any lawyer in the future do this? Oh, you got a judgment against my PC, I'm out of here.
I am not sure how often this issue comes up.
But I mean, it could in
and
the future if it
I
was a nice published
suppose, I
case.
suppose theoretically it could.
There'd be 3060 in certain circumstances that would mitigate against it.
Right, and it may require some changes in the rules, I'm not sure.
Okay.
I'm not aware of anything in the rules of professional responsibility that would prohibit a lawyer from doing this. There may be things that it kind of tangentially touches on, but I'm not sure.
So why should he be better off than if he had created a new PC? I mean, let's assume that if you had created a new PC, we would have pierced the corporate veil and said their successor liability. That may or may not be true, but assume for my question it's true. Well, why should he be able to do better than that by saying, I'm going to be a sole proprietorship?
I'm not sure if PC2 would be any more protected than acting as a sole proprietorship. I'm not sure. Presumptively, because we have this language in 156A, presumptively somebody who goes through a professional corporation that goes through bankruptcy gets its debts discharged. And we can start off PC2.
But we do periodically pierce the corporate veil when something like this happens, and we say that corporation number 2 now must bear the obligations of corporation number 1 because it is essentially the same thing.
That's right.
So let's assume for the sake of argument, again, I've not looked carefully enough at the facts. Let's assume for the sake of argument that we would have done that had he created a new corporation. Why should he be better off because he created a sole proprietorship?
I'm not sure if he is better off. I think if he had engaged in fraud, or if he had engaged in a lot of the improper conduct that Smith accuses him of, I think being a solo practitioner probably wouldn't give him any additional protection. So I'm not sure if that's necessarily the case. There's no case law in it, and I guess this is it. This is going to be it. But
That's why you're here.
that's why we're here. But I do want to touch on very briefly that we do have a whole issue preclusion, claim preclusion thing going on here from the federal courts.
Can you
But
explain your,
the federal courts expressly said we're not resolving that issue, didn't they?
The bankruptcy court said, the bankruptcy trustee said, well, okay, we don't think there's very much of this claim, but we're going to reserve it because they want to go back and do whatever they want to do. I go back to actually the U.S. District Court. Once this judgment came out and Mr. Kelley dissolved the corporation, why was it not incumbent on them to say, wait a minute, we have all these piercing the corporate veil and successor liabilities?
it hasn't happened yet. The whole point of the state litigation is because he dissolved the PC the day after the judgment. So it hadn't happened yet.
It actually had happened. It had happened in January of 2016, and an execution issued in the federal court in April of 2016, and there were efforts to conduct discovery and find out where the assets were, but even though it was available in the U.S. District Court, nothing was ever done in the U.S. District Court. What happened was in July 2016, the claim was filed in the state court. And we contend that, this all should have been litigated. It was available and should have been litigated in the federal court.
I may remembering the facts wrong. I thought the PC got dissolved the day after the judgment.
The day after I believe the judgment in 2016 That was January 2016, and then there was the execution, and there were efforts to collect. But there was no motion or effort to pierce the corporate veil once that had happened. And there's no reason that couldn't have happened. And also,
But tell me if I'm wrong, because maybe I am. I thought that the day after the judgment in federal court is when the PC gets dissolved. Is that wrong?
I'm not sure. I think it may have been the day after the decision. I don't know when the judgment issued. There's a pretty good chance that it was, because then there was an execution several months later.
There is a deposition in the record where he says, so to be clear, you dissolved the PC because of our judgment, that was the last straw, and he said, that's exactly why I dissolved it. I mean, so timing might be one thing, but that's the exact link.
Okay, so, but there can then be efforts to pierce the corporate veil and say, we have a judgment, and you dissolve the corporation, we want to get you, and the judge pointed that out, by the way. That was not done. And then in the bankruptcy, there was an actual, the bankruptcy court essentially said, you know, the assets of the corporation were worth $74,000, he paid $85,000. So I think any judgment would have to be limited to the $85,000 that he's already paid.
Okay, thank you.
Thank you.
We have a-
I'm going.
He's not here.
Maybe not.